Nsem-Pii TV nie.
Yamamako abie at the Nsem-Pii TV platform and so the office of the Attorney General, yes, Minister of Justice Godfred Odame Nankasa enumere wabe address Ghanaians, wasanso address the Supreme Court, our the assem ekwakodan omo, and 5-member panel of the Supreme Court, and omo ebetenase etie the appeal ya ebe kohonom etia Court of Appeal decision on the aba say wa akweti a discharge Dr. Case Autoforcing and Richard Japa in the Republic versus Case Autoforcing and 2 others ambulance procurement trial, which caused a financial loss of 2.39 million euros to Ghana. Now, Attorney General address Ghanaians and our trade Ghana for Adjunesis to say, "Ene rule ne buy no." And from so I won home I know to the Pimo Supreme Court and say 2 justices, Justice Kweku Akabuafo and a Justice Bright Mensa, and someone which now so Eddie Jai, Case Autoforcing and Richard Japano. And someone sebi a young tranchi answer. Esan say, Omujina, Omo asemo be catcher or monon kwa so and the dibu attain. Omo kwan all trial processes are koso a dance yahodwa ye dear gufom a etia case Autoforcing, Richard Japan Sylvester Animana. Niema Omo ye a etia earlier on directives the then Ministry of Health, the then Ministry of Finance, Omo e catcher omo. Various forgery processes as Sylvester Animana, no chief director or in the procurement trial. After no letters the then Attorney General Deputy Etroye nani nyina eko editia jumedi omudi in the procurement of all these ambulances. These 2 Court of Appeal judges did not consider all these matters, but rather they based on Case Autoforcing lawyers and some of the buy and omujina so edibu aten. Justice Pokwe Champon no yet presiding judge no no mum and consider in someone akoso and justice if you answer was a court nyina and nunti and more can say there be still na was a case Autoforcing and Richard Japa ekoko yi omo ho and the Attorney General akase ye padi nchirimu amagana for and could enter case no enso heya Autoforcing Japa e ho nto no yentie the full interview Godfred Odame are granted to Ghanaians and then
2023.
Yeah.
This is appealing on my vegetarian on the terminal and then that is it. That is why I am surprised by the outcome. But of course, it's not the end of it. I mean, Obi, this is not the first setback in my effort to prosecute these financial crimes. Even opening case in Pono had a setback. The same submission of no case ruling, which was made by the former judge, I think Justice Konyanuga, for Supreme Court first. So surprisingly, Supreme Court ruling by Justice Konyanuga. I had to go and review. I had success on review, and the ruling was reversed. The Samba High Court said we should have open defense. Then there was an application made. And the trial judge then stated that we have to start afresh. We have to start de novo. Because that's another Justice Konyanuga Wareta. Again, under strange ruling. It was one that really was also against all reasonableness. I took it in my stride and I appealed against it to the Court of Appeal. And I succeeded. It just as is normal, just as me I'm used to know. But I appeal against this one. And I'm very sure that it will be set aside. But really, the ruling there, in my respectful view, most unreasonable. And it goes against the essence of all the authorities on causing financial loss. Indeed, there is no case as clear as this one. There's no case in which the ingredients of causing financial loss have been established in as lucid a manner as this one.
But cousins, how kind the Court of Appeal decision now? Minya be 125 pages. But I was just taking a cursory look. So I share because I majority into a 2-1. So we share the first Justice Aoka 2 ne Justice Akabuafo paragraphs 149 150 151 of the decision now Okawa 149 or say the evidence further establishes that the ambulances were initially parked at the forecourt of the State House, but they were moved to the Air Force Base at Burma Camp by the National Ambulance Service at the direction of the Ministry of Health sometime in November 2015. Mr. Foster Ansong Brijan, PW1, who testified on 31st May 2022 said, quote, looking at the time we parked them there, the current state, the vehicles have actually deteriorated, unquote. 115 or say, my lords, if the above is accurate, in my respectful opinion, it defies logic that Jakpa at Business, agent of the supplier Big C, would be charged with causing financial loss to the state based on the fact in the record of appeal when the plan put in place to rectify the defect of the ambulances to enable their use has not been implemented because the government failed to meet its obligations under the roadmap agreed to in 2016. In any event, that roadmap leading to the shipment of the part to Tema Port was agreed upon between the Ministry of Health and Big C, not with Jakpa at Business. So it is not clear why Jakpa at Business would be asked, quote, to go and pay and clear the items to rectify the anomalies on the ambulances, unquote. As a corollary but to the foregoing, it bears mentioning that if there are vehicles, even if deficient in certain requisite parts, parked in Ghana, an action plan in place between the MOH and the supplier Big C to rectify the deficiencies and additional parts or accessories in storage at Tema Port for the said rectification, then there is a need to reassess the quantum of the alleged loss, a factor that impacts the case against all the accused in this case, and calling into question the maturation of the charges preferred against the accused persons. It's essentially, the justice of the court of appeal.
Yes, I heard everything. But the point, the judge, with all respect, misses the point. The financial loss was caused not because the vehicles were parked at the forecourt of the State House and were moved to a different location and were left to the vagaries of the weather. The financial loss was caused in the first place when the wrong specifications of vehicles were even supplied. Number two, the financial loss was caused because the vehicles that came were not ambulances, were not fit for purpose, and indeed could not be converted into ambulance. And I've told you that indeed there was a report from Ministry of Health and National Ambulance Services which show that the vehicles that were supplied were so fundamentally defective that nothing could be done. And indeed, this report from the license dealers in Mercedes-Benz showed that the vehicles that were actually supplied could not be converted into ambulances. It is a just vehicles see one more 10 days to 100 years to 10 weeks exit material. In the first place, the vehicles should not have been supplied. Wrong specifications supplied, not fitted with the relevant equipment, indeed could not be converted into ambulances subsequently. And if indeed a question which now converted into ambulances, from the part you really read, this thing that you're talking about occurred in 2015.
Yes. The
movement. How come from 2015 now up to 2017, NDC for legal officers, they couldn't convert it into ambulances? How come they couldn't fix the equipment? Because it couldn't be converted into ambulances. And that is not based on the oral testimony, it's based on documentary evidence from the license dealers in Mercedes-Benz, which we have stated in evidence at the trial.
Then based on what?
No, but the point about the fact that even the court for appeal was split in the judgment,
yes,
supports my view. Say the judgment itself is not sacrosanct. It's not one that cannot be impeached, because even the court for appeal, the court for appeal was divided. It was a majority decision, 2-1.
Yes.
And everything in my training and upbringing would dictate that such a judgment ought to be questioned. We have to test the soundness of the decision at the Supreme Court. Not as a matter of testing the soundness. For me, it defied, with all respect, every reason. Because, yes, the vehicles were supplied. Number one, the vehicles were wrong, were not the ones specified under the contract. Number two, the vehicles were bereft of all the necessary ingredients, as somebody would say, for one better expression, the necessary features of an ambulance. It didn't have all the equipment. Apart from that, they were defective. Even the engine capacity, the engine size that was set out in the agreement, the body and all that, all the interior parts were different from what was supposed to be supplied. Now, after that, more than 2 years, they could not be converted into ambulances because there's a report, technical report from those who deal in such vehicles, that those vehicles, with all respect, Ghana are useless because you can't convert them into ambulances. So, what again is a video? And as I said, so that's why I made the point there. You cannot have a much clearer case regarding financial loss than this matter.
Than this one. But now, me Busa Council say, based on what then would the Ministry of Health then agree with the suppliers on a roadmap to rectify, for which reason some parts were imported into this country? And you clearly heard the Court of Appeal judge Akabuafu make that point, say that roadmap was between the Ministry of Health and the suppliers. No, if they don't understand why Japa at business would be implicated in this matter.
So first and foremost,
yes,
even if this roadmap is valid, anything to go by, it's not after the fact. It's not after the wrong vehicles have been put into the country. It's not after the wrong specification and all the various breaches under the agreement has been committed. It's not also after payment has been made contrary to the laws of Ghana. Payment in favor of a company which did not have parental approval, even though they were supposed to have parental approval. Now, secondly, as I stated earlier on, which I'll repeat, indeed, that so-called arrangement to fix the ambulances could not be carried out because the vehicles should not be converted into ambulances. And it is not, I go for Odame saying it is as per the evidence that was stated at the trial. So the judges examined that particular evidence or they ignored it. If that evidence was ignored, then that's basis for us to have the decision set aside. And I do not think that there was an adequate assessment of the evidence of the prosecution from the judgment as I have considered it clearly. And if you look at the judgment, the dissenting opinion of Justice Pukwechabo, clearly it examined all the ingredients of the offense. It also examined the necessary material pieces of evidence that were tendered by the prosecution. And I think that is what is most important. So where, with all respect, one judge decides to look only at one version of the facts and which will support a certain conclusion, well, I think that it's up to us to question it on appeal. And I think this is not because of any emotional attachment about the case and all. I hold a very important office, Attorney General Minister for Justice. I'm responsible for safeguarding the rule of law. And I'm responsible for ensuring that where there's any decision against the Republic, which is really a dangerous precedent, that decision ought to be questioned. Unfortunately, this is not the highest court of the land, it's the Court of Appeal. The highest court of the land is there, and it will be examined there or to be composed by judges of 5 judges of the court, of the Supreme Court. So I think that indeed for the sake of ensuring that there's public accountability, upholding the rule of law, and in the interest of the fight against impunity, which is that if you are in public office, you cannot just do as you like. If one ministry responsible for a subject matter actually writes a letter saying that no, this transaction should not be proceeded with, and then another deputy minister, the Minister for Finance, who is responsible for protecting the public purse, Minister of Finance, before they make a payment, during the process they go through, even I as a treasurer sitting here, when I write letters for payments we made, they will go through and question and I have to justify. So the fact that you are the Minister of Finance doesn't mean that you should ignore or disregard all the factors that you have to consider before you make payments. But that's actually the most important duty.
Yeah, how about Council? How about the points? If there are any people to blame for what happened, it should be officers at the Ministry of Health, because the agreement essentially was between the Ministry of Health and Big C. Then
right.
Japa and the Finance Ministry.
No problem. And the same Minister of Health, as I've indicated to you, wrote saying that they did not want to proceed the transaction. And the same Minister of Health never requested the Minister for Finance or the Deputy Minister for Finance to authorize the payments for the vehicles. And the vehicles, as I've indicated, were paid for with the LCs that were established consequent upon the authorization of the Deputy Minister for Finance, Dr. Forster. So it's as simple as that. Minister of Health that you're seeking to blame, they self-wrote, said no, this transaction, you shouldn't proceed with it. That they do not have money to establish any LCs. Then someone sitting somewhere in another ministry, Deputy Minister of Finance, right to request for payment to be made. And there's no that at all. That request for LCs to be established was what resulted in the payment. But if you look at the agreement, the payment was supposed to be made through the establishment of letters of credit, through LCs. There is no other means of payment. The payment was by LCs. So if you write asking for LCs to be established, what are you requesting to do? In order to request for payment to be made?
But would you also say, sir, subsequent to the letter from Sherry Aite, for the want of a better expression, the counter letter from the AG in the advice, in this case?
No, the Deputy Attorney General then actually wrote that they should comply with the terms of the contract.
Mm-hmm.
And the terms of the contract would have required that one, you ensure that there's pre-shipment inspection done. If they had carried out that pre-shipment inspection, they would have realized that the vehicles that were supposed to be supplied were contrary to the specifications under the agreement. Yet, the payment was made when there had been no such pre-shipment inspection. So if you are Deputy Minister for Finance and there are terms set out in the agreement that you claim you are performing, and the Deputy Attorney General has advised that comply with the terms of the agreement, are you not going to check whether the agreement has been complied with? It's as simple as that.
In this case, no, that is
why in all these financial cases, a very important element is whether the officer in question was reckless or negligent. Indeed, complete negligence or recklessness is sufficient to actually show mens rea or the intention to commit the offense.
In this case, no, your understanding is the Deputy Minister of Finance then, for the reasons one find out if the terms have been complied with, pursuant to the advice of the Deputy AG, or for omitted that element, of course, in financial laws, right? That's your argument.
Yeah, it's not only him, but all those who are involved with the commission of the offense. We had initially charged the then Chief Director, who had also written letters at that time, and who had actually made some false representations to the Public Procurement Board. So the Chief Director, who was the second accused, actually, or catch a PPA was Big C was the one which negotiated for the funding of the project. But it was not true. The funding that he was talking about was actually a Stanbic Bank loan, which was never obtained. In fact, that Stanbic Bank loan was even disregarded. And then the Deputy Minister of Finance, Dr. Forster, then authorized that they should pay for the vehicles out of the Ministry of Health account. So it's not only him. The second accused was charged, but he was he was very, very much unwell. He had kidney disorder. He had to be flown to India. So we had no option but to discontinue against him. And then the person whose act also brought Big C into the picture. Big C supplied the vehicles pursuant to the introduction of JAPA, of Big C to the government of Ghana. The Minister for Health and all those public officers never knew about Big C. He brought Big C into it. And he even profited an amount as much as 700,000 euros after the 2.3 million euros paid. And how can it be reasonable that you tier for vehicles 2.3 or 2.37 million euros or 2.39 million, 2.3 million euros thereabout? That would be agents, middleman, or no, 700,000 euros. Anyway, this is Ghana.
Yes.
Now share on my YouTube channel.
Be the first to know Nsem-Pii TV.